5 seconds to go. Start. The bill, as I have said, seeks to repeal and replace the Act of 1920. Where was the need for this? It is not as if there was an immediate court case and the government had to come up with a new bill, or as if there was some other pressing need. The thing is that it just had been in the waiting for far too long. Many states tried to bring about piecemeal changes or amendments to the Identification of Prisoners Act of 1920. These states include West Bengal, Gujarat, Karnataka, Maharashtra, and Tamil Nadu. The last case was of Karnataka in 2021 when they sought to expand the definition of measurement and to include DNA, voice, and iris scans. However, the bill was reserved by the governor for the consideration of the Honorable President of India because it was felt that the bill was repugnant with the Act of 1920, which is a central act. So, we are where we should be. It is being said as if everything in this bill is new. The Act of 1920 provided for three things in terms of measurement. It provided for fingerprints and footprints, and if the magistrate so desires, photographs could also be taken. We also have the provisions from the CRPC under sections 53(1), 53(a), and 54, especially these two. The explanation provides as under, and I quote, examination shall include the examination of blood, blood stains, semen, swabs in case of sexual offences, sputum and sweat, hair samples, and fingernail clippings by the use of modern and scientific techniques including DNA profiling and such other tests which the registered medical practitioner thinks necessary in a particular case. Why have I brought this up? It is because a lot has been said about the legislative competence and perhaps how it violates the issue of privacy. These have been in existence already. They have stood the test of time and they have not been declared as violation of personal liberty by any court so far. This bill, however, takes it a little further and includes certain other things wherein the 1920 Act was found to be inadequate, and I must say that we all, most of us, in our younger days, have read detective novels of Arthur Conan Doyle about Sherlock Holmes and what a bright man he was, what uncanny sense of perception he had, but a Sherlock Holmes in today's day and age with his magnifying glass would look like an investigative dinosaur. A 1920 Act which provides for only fingerprints, footprints, and photographs is not the way to deal with crime and criminals of the 21st century. We cannot expect our police to be equipped with tools of early 20th century to deal with crimes and criminals of the 21st century. The modern techniques and the modern technology which is available to all of us, it provides for a triangulation that is now possible, which was unthinkable a century ago. Now, joining the dots using different identification techniques greatly facilitates and enhances the quality and quantity of criminal investigation. As our Home Minister said in his opening remarks, the idea is to get the conviction rates up, and those cannot happen unless scientific methods are adopted and used by our police forces and prison authorities and in the overall criminal justice system Only then such an improvement is possible. The previous Act of 1920 was also limited in its ambit, and the present bill seeks to expand it further by including what is referred to as other persons, though most of it is from the previous Act, under which a convicted person's measurements can be taken, and then someone who has been ordered to give security for his good behavior can be asked to give his measurements, and someone who is arrested for any offense under the existing law can also be asked to give his measurements. But yes, the police powers in the present bill have been increased. The magisterial powers remain the same. They have not been tempered, but the police powers have been increased. But in this day and age, you have multiple sources available as far as data is concerned. You have the banks through KYC. They have almost all your data. You have the Aadhaar. It has your biometrics in any case. You have the election commission. It has a lot of your details, and all these private players, whether it is Google or Microsoft or whichever company is dealing with these meta database, they all have data. So, just to restrain the police from not collecting data, which will be useful for them in investigation and execution of cases before the court, somehow seems to be just a measure which one has to do away with. We must move with the times, and we must use the modern techniques and technology which are available to us. Sir, I will point out just two things because a lot has been made about privacy. There are two provisions which are very important. They have been mentioned in the proviso under section 3 where the person is given a choice. There is no use of this word. Otherwise, this is a word in common parlance as far as the liberal world is concerned. A person is given a choice where it is said that he may not be obliged to allow taking of his biological samples, and there are conditions with this. So, there is a choice given to a person. It is not as if it is not given, and in any case, there are plethora of judgments where in criminal jurisprudence may is generally read as shall. So it is almost a given in this. Similarly, the proviso under section 4 provides that the measurement will be destroyed. It will be destroyed if the person has not been convicted before and if he has been discharged or acquitted by the court of law. So that is to be destroyed. So when we say that under trials and political protesters or activists are arrested for something, they are clubbed with the hardened criminals or those who are charged with serious crimes. That does not hold because if the person is not convicted or if the person is discharged before that, the data which has been collected in that case will be destroyed. Lastly, sir, since I do not have the luxury of time, one point which has been very conveniently missed out by everyone is that this bill provides for a great amount of legislative oversight because ultimately this bill and its effectiveness and efficacy will come from the rules which will be framed under this act by the central government and by the state governments. Stop.